Hello and welcome to the Arbitration Conversation. So in this conversation, we're going to talk about an important issue, transparency. Often arbitration is considered, of course, private because only the individuals who are invited to the arbitration hearing can be there. And it's often confidential, of course, but that must be pursuant to the parties' agreement that it be confidential. But really, why should we care about transparency and how can we sort of look deeper into transparency? And for that, I have a true expert, an expert in arbitration, an expert arbitrator as well, Janet Walker. So Janet is an independent arbitrator with the chambers at Arbitration Place, Toronto, International Arbitrators, London, and Sydney Arbitration Chambers. In Australia. And Janet served as arbitrator in matters administered in many of the major institutions in a wide variety of seats. She just a distinguished research professor at Osgoode Hall Law School and author of Canada's main text on private international law, cited more than 400 judicial decisions, widely cited. So Janet, it's so great to have you here, given your background and your expertise. It's really great. Thank you so much for taking time with us.
Happy to be here, Amy.
So let's dig a little further into this question of transparency. So what does transparency have to do with international commercial arbitration?
We've heard an enormous amount about international state-to-state arbitration, ISDS, and other arbitration involving important public issues. And transparency is obviously critical there, where the outcome has a very significant impact on the wider public. The public want to know what's going on, who's deciding these cases, what is the forum in which they're being decided. The question is, though, what about international commercial arbitration? As you said, Amy, it's private. And when it's a commercial matter, you might say, well, why do we need it to be transparent? Why do we need it to be open? And on the one hand, the pressing public issues may not apply. I must emphasize, there isn't a clear divide between them. So where there is a public issue, a state entity or an infrastructure project and so on, there may be a public concern. And of course, that will bring with it the need for public accountability. But that's really what it is. Transparency is all about accountability. And so the question is really, why do we need accountability in international commercial arbitration? What is that for? And who are we going to be accountable for and what? Clearly, for the business community have an interest in it being run efficiently. It's a market service, a market-based service. So you need to know what's on offer in order to make wise decisions. But the international commercial arbitration community itself wants to provide a reputable and reliable and efficient service for the larger public, and so has an interest in being transparent to the extent that that will provide confidence or will create confidence in the process that they offer.
Yeah, definitely having information and transparency does increase confidence, right? Because there's a lot of discussion that maybe, well, if we don't know what's happening behind the curtain of arbitration, there could be things like repeat players, advantages, and other concerns with the private nature of the information. So the question is, aren't we awash in certain information? I mean, it seems as though we're hearing more and more. You can Google and find information, even just news items and different things posted about commercial arbitrations. So don't we have almost too much information in these days? So when we talk about information, what kind of information should we have?
I would say there is a huge amount of information available to all of us. When you think back to 15, 20, 25 years ago, you can think of days in which you could probably count on one hand the number of events, the number of international events going on in a year. You could probably go to all of them if you had the opportunity. You would have to go to all of them because that was really sort of all there was, apart from Redfern and Hunter, Craig Park Paulson, and a few other texts. There really wasn't a lot written about it, and it was all anecdotal. So it was all sort of know-how that had been developed by the few people who were doing it. Also, it was, when you think of the few people who were doing it, it was a self-described mafia. So the theory was, if you were in the mafia, you knew who you were, and somehow the parties knew who you were too. And if you weren't, then you wouldn't know anything about it. fast forward, I mean, to today, and you open your inbox in the morning and it's just inundated with current awareness, updates, latest, news from people, invitations to conferences. We see conventions and conferences going on throughout. The pandemic has been no stop to that. So there is a huge amount of information out there about arbitrators, the commercial indexes, the conferences that they speak at, now the webinars that they speak at, their own sort of websites, the arbitral institutional panels providing information about arbitrators. We know about the institutions, their rules reform are all very public. Now they're publishing information about challenges to arbitrators, about arbitrator panels that are being appointed, all kinds of things sort of about the process as well, the soft law developments, the sort of common principles, all explaining to the wider world what goes on in arbitration, who is engaging in it, and everything that you think you might want to know about it. Still, somehow, the thirst for information continues, which is a fascinating point, isn't it?
It really is. I like this. I mean, you're absolutely right. I'm sitting here shaking my head. Yes, yes, yes. I mean, this arbitration conversation is guilty of providing more information about arbitration and arbitrators. I guess though, there is this concept of information overload, right? And it becomes such that you don't know which information is A, truthful, B, what you need to know. So if we were to kind of work on this question of transparency, right? And in this perfect world, what type of information do we need to sort of organize maybe for individuals in order for it to be helpful and to really help the transparency, the kind of transparency that would be useful for access to justice and sort of allowing individuals to feel more confident about the process and the arbitrators?
I think you're absolutely right. We're in a kind of a funny situation here, which we are, frankly, in the world more generally, now that we're in the information era. We're being inundated with information, a lot of it because there's a lot of promotion going on. And naturally, arbitrators rely upon appointments to do their work. And so they're going to be natural self-promoters. Institutions are obviously competing for work. So we can see, venues, seats, we can see that a lot of that information is being pushed out there, and it can be helpful, but we can be quite overwhelmed. And you'll say, well, we need to sort it out. We need to find ways to compare and ways to choose wisely. How will we do that? Some of it, I think, is organizational. Some of it is also getting a sense for what is it that we really need to know. Some of the things that I reflect on, for example, as an arbitrator, is I know an awful lot of people in the field through conferences, through various communications, but you never really know until you work with them. Some of the people, they may not be front and center, but boy, are they responsive. Boy, are they reliable. They've got good sense and they're willing to roll up their sleeves and get on with it. Some of the others, sadly, are wonderful self-promoters. They can certainly talk the talk, but they don't always, they're not always available, accessible, helpful, good to work with when you have that opportunity. So sometimes you think, well, I would only really know if I worked with them. Others, you think, well, there's a great reputation there. How does it actually work for the parties? Now, I know the institutions, they have feedback forms and that sort of thing, but we're always looking for that sort of that magic bullet. I don't know if there is one, but two things that I think are on the horizon that I think are really, really interesting and really spaces to watch. First, the more detailed indexes. I think there's one being developed now with arbitrator intelligence, very detailed, very thorough. Who won the last case that this person arbitrated, what was awarded, what percentage of the claim was actually awarded, was there a counterclaim, was that denied, what percentage, and all looks very interesting. But once again, information that you wonder, how will it be interpreted, how will it be used? I sort of get a little bit nervous when I think of the potential for sort of moneyball arbitration. Whoa, that person has done, in the last 3 arbitrations, has awarded 100% to the claimant. Well, that's great. We're going to be a claimant, or we're going to be a respondent. We want to object. And you want to think, well, maybe it depended on the case that was actually being presented. So some of these things can actually be, as you say, difficult to interpret and difficult to sort out. Very interesting to see how that plays out and how useful it becomes. Another area, I think, in which we might get more information is with the publication of awards itself. We see this being sort of promised or threatened by institutions, increasing number of institutions, and we'll see if that actually happens. You would potentially see a lot more about the inner workings of the process if you read the award. You would get a sense for how did the procedure unfold? Was there any ingenuity? Was there efficiency? That you might be able to see through the way in which the process was described. You would also get a sense for the arbitrator or arbitrators' thought processes, how they analyzed an issue, how they developed that. But once again, I'm a little bit concerned about that because we see now the concern about ISDS and how arbitrators, having publicly committed themselves to a particular view on a particular question, might be thought likely or expected to make the same kind of ruling in what would seem to be a similar question going forward. Now, with commercial arbitration, the issues tend to be far more varied and diverse. So the assumption is not necessarily going to be the same. But once again, one might wonder to what extent anticipations might be disappointed or they might be exaggerated. So those are 2, I think, areas where it will be interesting to see whether more information will be useful. But once again, I also am hoping that people will not lose that sense of I won't say the magic, but the dynamic that is developed between the parties, between the council and the arbitrators. That is something you really can't report on or capture outside the actual arbitration itself, which is something that really can help to make things move forward. Frankly, you can talk about that recipe. You can describe what goes on, but you can never really, as I say, bottle that magic that in an arbitration it really works well so as to capture that and convey that to others. So yeah. As much information as we get, I'm sure we'll never have all the answers, and we'll also want to have reasons for preserving the privacy and the intimacy of that process. But it's an interesting process that we're all living through.
Yeah, I think those are all really great points. You know, and I really love the point about you have to work with them. And it's so true. You really don't know unless you have actually worked with an individual in a process. But yet at the same time, I agree, it's important that we kind of pursue these different ideas about more transparency in commercial arbitration. Also, just because otherwise, if the information is only in the hands of maybe the large law firms with solid databases or whoever, trying to make it information that's available for everybody, regardless of whether you are a repeat player or a one-shotter.
Absolutely. And Amy, can I say you will be another purveyor of very useful information in the time ahead. Just having seen your list of posts, I think they look tremendous.
Well, I'm just really happy and thankful that you are in that list. So thank you so much for taking time. I think this question of transparency is a rich and textured question. I love the way you've thought about it in such a deep way and really thoughtful manner. I just am really thankful that you took the time with us. So thank you.
Thank you. Okay, bye-bye.